Get started now. We at least have a quorum for the meeting, and for the benefit of the court reporter, we'll have everyone introduce themselves up here, and I'll start with our friend Mr. Meadows. John Meadows, would you?
John Meadows, I represent the 5th District.
I'm Trey Kelly. I represent the 16th House District.
I'm Mary Margaret Oliver, House District 82.
And Wendell Willard, House District 51. And we have on the other end of two of our Legislative Council, the lovely, whimsical Jill Travis. Thank you all. Let me have a few things to talk about before we get underway with the hearing today. One point of order I want to make is address before we get started, and that is to individuals who have contacted members of our staff as well as members of the committee about the meeting today. The purpose of this committee is found in House Resolution 1363, and in sum, the task that we're charged is to investigate the operations of the Judicial Qualification Commission and undertaking a study as to the conditions, needs, issues, and problems therein. These meetings are for the committee to conduct that business. Whether to accept testimony or extend invitation to the public or any matter is subject to that mandate, and the rules of the committee are interpreted by me as chair. We are not conducting hearings to receive testimony from individuals as to how their own individual complaint may have been handled through the JQC. We're also not determining the manner and makeup of the court's assignment of cases to the Division of Courts, in this case dealing with the family law issues. That being said, as discussed at the end of the first meeting in September, upon adjournment and after a brief recess, I'd like to ask the members who wish to remain, please consider doing so there'll be some feedback from those individuals who have contacted our office and wish to provide suggestions or improvements to the constitutionally mandated work of the JQC Commission. We've allotted up to 30 minutes for that purpose today. Anything beyond this area will be considered non-germane to the committee's work and may be ruled out of order by me as chair. We have today at our invitation a member of the JQC, and that is Mr. Ed Tolley. Ed is from Athens, and I've known of him for many years. I don't think ever had a chance to meet, but I've read of your work and admire it very much. And I know when I was informed by a bar representative of your potential being named as a member of the JQC, I was very, very pleased, because I know you carry with you a great deal of integrity, and your reputation is stellar. So with that, and the past practice we've had, Mr. Tolley, is to allow the speakers to give an opening statement, introduction, and go through what you would like to present. Let me just say, as a prerequisite, I understand the work you've been doing as a part of what we call the Justice Namias Ad Hoc Committee, which is looking at the current rules of the JQC and to see where and what manner those rules might call for some changes and other things addressing the procedure of work and operations within the JQC. So with that understanding, I would like to then turn it over to you, let you address the committee.
Thank you, Mr. Chairman, and thank you for those kind words. I'll try to live up to those words. I have prepared some remarks because I think in doing so I might be able to focus everybody on what we are trying to do, which is to fix the problems that I see and that others see with the commission. I've thought this morning that sometimes it takes a little bit of controversy to force people to focus on the problem and fix it. And we've had some controversy, but I think people's attention now is turned to getting it done. I started practicing law in 1975. That's when I was sworn in to the practice of law. And to be very honest with you, I'd never heard of the JQC. Probably in the 10 years into practice before I knew what the JQC even was. We did some research. Justice Namias gets credit for this, and tried to figure out who wrote the original JQC rules, which have not been materially amended in 4 decades. They were written in 1970 and approved by the Supreme Court, and nobody knows who wrote them, and what document they were drawn from, and so on and so forth. Of course, they're constitutionally mandated, and we've observed that. How did the judges, and Chairman Willard, you probably going to recognize some of these comments, how did the judges treat us years ago before the JQC became such a big deal, it seems? Well, most of the judges in the communities were leaders in their communities. They were church leaders. They were thought very highly of. They were thought to be sages in the community, and people respected those judges. And I think that's the way it ought to be, and that's the way we ought to get back to, is trying to make sure our judges are respected and that the community recognizes them as community leaders. But it wasn't true of all judges. I'm an old timer, 42 years practicing law. I appeared in front of some real tough customers who were very, I thought, unfair to people, unfair to litigants, unfair to lawyers. And back in the old days, there was an awful lot of ex parte stuff going on. And so as a young lawyer, I watched all that. I didn't think it was right, still don't think it's right. And a lot of what our work involves today is trying to make sure things like that don't get overlooked. There's a number, of course, one of the oddities in Georgia is that we have so many judges that aren't actually lawyers, and that's not to be critical of them because some of them do an outstanding job, but we also have some non-lawyer judges that I've observed in my short time on the commission who really watch too much television, and so we have to deal with that as well. The open courtrooms has been a sensitive issue. And I know one of the judges that was here, that was part of the problem. I've written 3 articles on the constitutionality of open courtrooms. I think it should be a dead issue, but yet we continue to run into those issues. So I just want to make that comment. This commission, as I understand it, and I wasn't there previously, operated on only sworn complaints. And I noticed in reading about the previous hearings that this has come up and has been an issue. Around 2007, my research and reading and hearing leads me to believe that a wider net was cast. It appears that frequent sources of complaints came from fellow judges, from court staff members, and from court reporters, which I find to be interesting. But I think it's a very important thing to think about, and that is whether or not to require just sworn complaints in order for the JQC to effectively do its job. Because honestly, what I've seen, most of the stuff is coming from other judges who, complain that my fellow judge doesn't ever come to work. Maybe there's a drinking problem. Maybe there's a clerk that's concerned about going into the judge's office. I mean, you hear all varieties of this. And it should be our responsibility to investigate those things. I'm going to really go back in time because I remember cases that weren't brought on sworn complaints. For example, I remember the Georgia Supreme Court in 1977, I believe it was, removing a Superior Court judge in Barrow County because he ordered the court reporter to change the official transcript. And there was no sworn complaint. There was no, he was just removed. And then I recall representing a Superior Court judge who had inappropriately placed his hand on a female attorney. It was a given. And there was no formal complaint. He was asked to resign. He resigned. He was also prosecuted, and we resolved that question. So the idea that complaints have to be sworn in order for the JQC to act or the Supreme Court to act or any of us lawyers noticing bad behavior and doing something about it, I think is appropriate. Now, in 2007, there was a sea change, as I understand it, in that the commission began to operate on information received. And that has led, and I have to be honest with you, it has led to a shocking number of removals of judges I think 60 was the number, or 66. I mean, to me, that's shocking, and I guess I was naive. Some of the Superior Court judges who, in particular, who resigned, were personal friends of mine. And I was disappointed. I was disappointed to know that people have done some of the things that they've done, but that doesn't excuse the behavior, and it doesn't mean that they should not have been asked to step down. In most cases, it appears that all it took was a contact by the investigator and admission by the judge, and then they stepped down and others took their place. I'm hopeful, this is just Ed Tolley talking, I am hopeful that today a lot of that bad behavior has been rooted out and that it's going to slow down the process of the JQC having to remove judges. That's a very difficult thing, and I think it's very upsetting in a lot of communities when that happens. For me, I guess it falls in the category of what were you thinking, guys? You know, what were you thinking when you did that? Why am I saying all these things? Because the press and the public needs to understand, in my view, the importance of the work of the JQC. I mean, I know you recognize that. This commission has not been put together to dissolve the JQC. That's, a lot of people have thought that. I don't think that. I think the idea here is to fix the problems. But the fact that the JQC is necessary is demonstrated, as they say, the proof is in the pudding, when 66 judges based on bad conduct have to step aside. That's a lot of people. And so the JQC is important, and we need to do whatever we have to do to make it work. Now, again, these are not comments that I've heard from Justice Namias or anybody else. These come from Ed Tolley. But there's been so much drama around this, Chairman Willard. There's so much drama. It's just not that complicated. Right. You know, we just need to take it, ratchet it back down to being a working commission that does its job. Let me give you an example, Chairman Willard. The letter that you received from one of our previous directors, that 6-page letter that I was privy to, I thought, what in the world? Where is all this drama coming from? I mean, the request was pretty simple. Just come and tell us the way you operated when you were there. And so, you know, that's what I'm talking about. I want to see that kind of thing ratcheted down. It is true that there has been a coincidence of what I call newsworthy events. I mean, obviously we lost directors. We've lost a chairman now. We're operating without a chairman and without an investigator and without a director. These are newsworthy events, but they're not events that can't be fixed. I would like to make this observation, if you'll permit me as well. I am not unaware of the Becker situation. I knew Judge Becker quite well. I've been on speaking panels with her. I was not aware of what happened up in Bartow County, but I read about it. And the only thing I can say is that if all of what I've read is true, and maybe some is and some isn't, the problem is not necessarily with the process. The problem was with the people who administered the process and the manner in which they administered it. So I just don't want to see the baby thrown out with the bathwater because one person or two people did something that I think might be inappropriate. Bear in mind that 20 months ago, nobody even knew what the JQC was, and because of all the publicity, I've got some comments about that in a minute. Leadership goals. We need an investigator. Mr. Hyde resigned as the investigator, and the governor placed him on the commission. So he is really not an investigator for us anymore, but we need one. And I have recommended to the commission, and I think we're going to vote on this Friday, that a retired FBI agent, it's a woman who was head of the Organized Crime Task Force. She's pretty strong. She's retired, and I've recommended to them that we hire her as an interim investigator. She is vigorous, talented, and has agreed to do it if the commission will hire her, which I hope will occur tomorrow. We need an investigator more than we need anything else, because the backup on some of these complaints requires feet on the ground, statements being taken, and then a decision made as to whether to take them to hearing. So I'm hoping that we solve problem number one, which is the investigator tomorrow. And I might add that this investigator has said she was willing to work on an interim basis. She's not necessarily interested in being there forever, but I think it's a good opportunity for us. Now, the directorship. It has been suggested, and I completely agree, that having a director would be a great thing. I mean, it's sort of been a train wreck with Judge Lane, who I knew well, went to law school with him. Judge Lane resigned, and I guess because of some issue about retirement funding. So Judge Lane resigned, and then Mr. Daler has resigned with some fanfare. And so we're without a director. And what we've been doing, and I don't mind telling you this, is we've just been trying to handle the business without a director. We're not, you know, by legislation right now, we're not even required to have a director, but it makes sense. And so we've been doing that, and I have made efforts, Representative Oliver, I have made efforts to talk to people about taking an interim directorship. And this is kind of the feedback I get. First of all, primarily, if it's people that have been in state government before, they are concerned that it would affect their retirement because they're aware of the Ronnie Joe Lane situation. In other cases, to be very honest with you, there's a hint of scandal around all of this, and people don't want to be associated with it. Maybe I shouldn't be, because I've been practicing law for 42 years. I had other things I could be doing, you know. But honestly, I'm happy to be here, because I think, and I have now come to believe, this is a very important job. And so, but you know, we're working on that. We'll get there. We'll find somebody. But what I'm hoping is that the voters solve that first step for us, and then we'll know what direction to go. And then it'll be easier, I think, to get a permanent director. But I want to assure you that the work has not stopped, Chairman Wheeler. It has not stopped. We are working on these files as best we can. Now, since the JQC has received so much publicity, we've had an uptick in complaints. Not a surprise. Right now, I talked to Tara Moon, who's the longtime, you know, just administrator, jack of all trades, takes out the trash and returns the phone calls. 550 complaints. I know, it's a lot. And here's the deal. Most of the complaints that I've seen in the past month and a half have been complaints. I haven't seen all 550, but most of the ones that I've seen in the past month and a half have been primarily people complaining about rulings that the judges made. And the bulk of those, which we don't have jurisdiction over, and the bulk of those have been in domestic cases. The judge gave custody of my daughter to my ex-husband, who's a drunk bum, and the judge is an idiot, you know? And so we don't have jurisdiction over those. Those are easy cases to turn around. I personally, and this is not a joke, I personally screened out a complaint where the litigant's complaint was that she did not like the look on the judge's face during the evidence hearing. So, you know, I understand that people are frustrated. You know, this whole country talks about frustrated voters right now. People are frustrated, but we are not the place to take those frustrations, and I think we have to understand that as commission members. But I tell you all this just so you'll understand we got run over because of the publicity with people unhappy with their trial judges. And that's not fair to the judges, and that probably goes to the issue of why confidentiality is important, because a good judge who stays there, I mean, I don't know about y'all's circuits, but my 4 Superior Court judges, my office is right across the street from the courthouse, and it is not unusual at 9 o'clock at night to see Judge Stevens' light on, see Judge Norris' lights on, Judge Sweat's light on. These judges work hard, and they want to protect their reputations, and I completely understand that. Now, let me move to the next issue in my mind, which is due process. The JQC due process, it needs fixing. There ain't no question about it. The due process needs fixing. And let me give, if you don't mind my saying it, Representative Oliver, I think Chairman Willard, you and me may be the only ones that remember this. But in the old days, if there was an issue, for example, if you had a client who got a traffic ticket, but their license was in jeopardy, you could ask for a hearing. You could ask for a due process hearing. So when you go to the due process hearing, guess who the judge was? State Patrol captain. And so, you know, and that was true of a lot of the agencies, and that's just the way it was. Well, was that a terrible thing? Well, this is what General Bolton, who I also knew, said. He wrote an opinion in 1964. I was in high school then. Attorney General Bolton said that the purpose and the intent of the law is to provide uniform minimum procedural requirements that should be followed. Well, that that basically is what you have with the JQC. And here's the problem with that. Everybody else has moved on, okay? We have administrative law judges now. We have robust due process. And right now our judges, I mean, I don't want to cast aspersions on anybody, but it's obvious to me that this due process problem needs to be fixed. And I'm going to make some recommendations in just a minute. Now, well, I'll make them now. What shouldn't happen is that the people who initiate the complaints, the commission members, are also the people who prosecute the judge. Those functions need to be separated. And I've got some recommendations on how we can do that. Judges are professionals. I'm giving them the benefit of the doubt. They need to be treated with courtesy, and they need to be provided due process. You know, every day, I'm primarily a criminal defense lawyer. Every day I'm yelling at some judge about providing my client due process. And yet, when the judges come in, we're both prosecutors and judges, and it's just not a really good system. I don't think that people intended for it to be that way. That's just the way it is. Now, rules changes. What has our committee been doing? The old rules, as I said already, satisfied minimum due process requirements consistent with the Bolton opinion, but now are inconsistent with modern jurisprudence. There has not been a comprehensive review, as I've already said, in 4 decades. Now, what to do about it? 4 or 5 years ago, Justice Thompson started a program or a study committee to rewrite these rules, but it just didn't get very high off the ground. And that's what I meant when I said sometimes it takes controversy to go ahead and push things forward. And so here, what we did, we met and we said, we are going to scrap the old rules. We're not going to start with the old rules. We're going to start with new rules. And so where would we go? We went to the American Bar Association model rules. They spent almost 10 years developing these rules. And we drew on those rules and the experiences of other states that have adopted it. For example, just to show you how far behind we are, the rules that we presently have were the same rules that Florida had 15 years ago. So we definitely got to move in the direction of the ABA. Justice Namias has, as he's wont to do, and that's a compliment, Justice Namias, is very detail-oriented. And so he has prepared a paper that I'm not going to read this whole paper to you. We'll be here till tonight. But I do want to comment on a few things that he wanted to make sure that I commented on, and these are as follows. Based on lessons learned from the Code of Judicial Conduct Revision Project, which has just been completed, we decided not to use the 40-year-old current JQC rules as the baseline. The model rules must be revised to conform to Georgia's constitutional and statutory requirements and to reflect the experiences of the JQC. Because the constitutional and statutory law are presently unsettled, we can, at this point, only offer outlines of the major rule changes that we expect to recommend. And, of course, all of this, at the end of the day, is going to be up to the General Assembly. I certainly recognize that. And please, by any comments that I make, do not believe that I'm trying to tell the legislature what to do. I'm just telling you what our research has shown. We would strongly recommend the implementation, we strongly recommend limiting the implementing statute to the core issues of JQC composition, including the appointment and removal of members and filling of vacancies and immunities from suit, leaving the nitty-gritty day-to-day procedures to the rules that are promulgated by the Supreme Court. This allows the procedures to be adjusted by the JQC with Supreme Court approval more easily in light of developing experience and best practices. I think what he's saying there is the legislation doesn't need to be so broad that it tries to hit every point, that a lot of this can be handled by rules. Objective number 1, this is a unanimous committee recommendation, is separating the investigative and adjudicative functions of the Judicial Qualifications Commission. Now, how did the American Bar Association recommend that that be done? They have recommended that we move from the small commission that we have to a 12-member commission. 3 would be hearing officers. 9 would be the investigative panel. And I've got a chart which I'll hand out and show you all in just a minute. Now that's a lot more people than we've had in the past. But right now, if we tried to do it with 7 people, it's just not going to work. There's just not enough people. So by separating that, we feel like we could be a lot more effective. Now, bear in mind that even in a good year, there's probably 400 or 500 complaints. So if you have 9 people working on these complaints and an investigator, you can get a lot done. We won't be so far behind and people fussing at us. And then in the rare event when hearings are held, and they are rare, then there would be a special 3-person panel that is, I think as Richard Hyde said, they don't even send Christmas cards to each other. They're totally independent, and they'll have a totally independent counsel. The investigative panel hires and supervises the disciplinary counsel or the director and investigates, supervises, and investigation, approves the dismissal of complaints, et cetera, basically what we're doing. The hearing panel would try contested cases and make disciplinary recommendations to the Supreme Court. In this way, the hearing panel would function much like a trial court, adjudicating cases and sentencing those found to have violated the rules. And of course, we're going to recommend that a Superior Court judge be the head of the hearing panel. And I'll show you again in the chart in a minute. Now, the ideal structure of the JQC. This is, again, from Justice Navis's notes, and from my notes as well. The JQC should consist of 3 classes of members: judges, lawyers, and the public. Members from each class should be involved in every function of the commission, and ideally all classes should have equal voting power and appointment authority should be dispersed. Now, I don't really want to get into, unless asked, about appointing authorities. I mean, that's not up to me. The way I look at this, there's a lot of ways to fix this. We're going to come on with a pretty strong recommendation, but it needs to be fixed. And that's kind of interesting because it's really not the position that I originally thought I would be taking. I originally thought, because a lot of people were upset, that I would be opposed to the constitutional amendment. I can't look you in the eye today and tell you that I am. I think that now that I've seen the due process problems, the fact that the commission's really too small to operate properly, the fact that we're out of touch with what everybody else is doing, I think we need help. And not apparently, the only way you can, by statute, fix the problem is if the amendment to the Constitution is made. So
why is that?
Well, because the Constitution, we're a constitutionally based commission. That's my opinion, and we have to whatever we do, we have to do it in compliance.
I want to touch that subject. I didn't interrupt you, but
no, that's fine.
I think it's a material point that we're trying to look at, and that is the current constitutional provision is very structured and not flexible as far as how things can or cannot be done.
That's
in
correct.
The operation of the Judicial Qualification Commission. It mandates 7 numbers. It mandates other things as far as their process and procedures. And as you talk about making change that may bring about the solutions to the problems you're addressing, to me, it's really not capable of being done with the current language we have in our Constitution.
Oh no, you're exactly right. I agree with you 110%. In fact, if the voters don't pass this constitutional amendment, then where we're going to be at is to just do the best we can. We're going to be right back to doing the best we can, and we'll do that if the voters don't pass the constitutional amendment. I'm not quitting. We're just going to do the best we can. But I think you're exactly right, Chairman. Now, there has been, and I'm not going to avoid the issue. There have been a lot of concern by members of the State Bar of Georgia about the fact that the State Bar of Georgia has lost some of its ability to appoint people if this passes or if the legislation as it exists directly. I would only say this, Chairman Willard, and I'm talking lawyer here. No one knows the lawyers of Georgia better than the State Bar of Georgia. So whether it's by recommendation from the state bar or by direct appointment from the state bar, I think the state bar should be involved, and I suspect you do too. So I just want to make sure that
Yes, sir.
that I'm not avoided the issue. There's some other little details that I'm not sure you're really that interested in today, but I'll touch them real quick. There's no provision for recusal of members of the JQC. So, we can wind up, for example, with one case we're dealing with right now with everybody recusing, and there's no provision to replace us.
Is that going to be addressed in your rules?
Yes. And then removal. I guess if I turned out to be a sorry drunk and they wanted to get rid of me, there's really no way to do that right now, but there will be a way in our proposal. Okay. Vacancies, same thing. Chair of the JQC right now, the bill is, if I understand what I've read, the governor would appoint the chairperson of the commission to be consistent with what everybody else is doing, and I'm not here to tell the governor what to do, okay? But to be consistent with what everybody else is doing, what would normally happen is that the JQC would elect its own chairman. That's typically what happens. That's what happens right now. Confidentiality. This is a huge issue. There's some judges sitting back here in the room. And for all the reasons that I just said, all of these little, I'm going to complain about the judge's the look on her face when she made her ruling. Confidentiality of these complaints, I think, is important, not just to the individual judge. If you're the judge being complained of, it's important to you and your wife at home and your kids that go to school. But the reality of it is important to the public. In my opinion, it's in the public interest that we don't denigrate the judiciary in this state to the point where people don't have any respect for it. I mean, they're already coming to court in T-shirts and holy blue jeans. And, I tried a federal case down there before Judge Edenfield died, and you probably knew him, just 3 or 4 years ago. And he made every male juror wear a coat and tie. And if they didn't have one, he had the marshal dress them every morning. Now, telling you, that may sound silly, but they were on time like this for the whole trial. It's an important trial.
Should be like going to church.
Yes, sir. It should be like going to church. And we've kind of lost a lot of that. And I don't want the commission to send this message out to the public and get it picked up by the newspaper that we're not promoting the integrity of the judiciary. I think that's important. That is not to say that if a judge does something, what were you thinking, that he or she won't have to pay the price for it. I mean, that's just the bottom line. So confidentiality is a huge part of what we're going to recommend. Exceptions to confidentiality. I had a firsthand view of this one. You might know that I'm on the I got to quit saying yes. I'm on the Georgia Public Defender Council. I'm also the chairman of our local council. And the way we have done things with these other commissions is that we are open. We're open initially, and then we go into closed session for the confidential things. When I first was sworn in Macon, Georgia, to this commission, I was met on the sidewalk by a bevy of reporters, and then there was a big deal about whether they could film me being sworn in or not. Asked me if I cared. I didn't care. And so eventually I said to my fellow new commission members, I'm happy for the camera to be here. I don't care. And then they took my picture and they left, and that was fine too. I think that we create some of our own problems. That's why I'm here. I think we create some of our own problems by not being more open about some of the things that we're doing. I mean, I'm not embarrassed to be here, and I'm happy to be here. And I really believe that certain confidentiality exceptions should be made. For example, the JQC should be able to provide otherwise confidential information to a person to protect that person and to appropriate authorities. What the heck does that mean? You can tell that a brilliant justice wrote this. What it means is if a judge has done something to a person and that person doesn't feel safe, that the commission should be entitled to inform that person. Okay, that's all it means. The JQC should also be able to respond to requests for information from state and federal judicial nominating commissions. Well, we do that now, and that should continue. I mean, one of the questions that I know we get is when the governor's looking at somebody is, have they had any complaints? I mean, I think those are things that the appointing authority is entitled to know. The JQC should be able to provide confidential information when the affected judges waive confidentiality. That has happened in this case. The JQC should be able to confirm the existence of an investigation where appropriate after the investigation of the or its underlying subject matter has already become public. Okay. Now, let's just look at what happens in a big high-profile criminal case. What our ethics rules there say is that the prosecutor, and the federal prosecutors are more careful about this than the state prosecutors, but the prosecutor is limited to saying, we've returned an indictment today, we've charged Jack Jones with 3 counts of murder, we expect to vigorously prosecute the case. What they're not expected to do is to say to the public, this man is guilty, we're going to get him, that type of thing. Well, I don't see any reason why in dealing with JQC matters, if something has already become public, if Judge Jones has already been on the front page of his local newspaper, I don't see anything wrong with us being able to confirm that an investigation is underway. And that's actually, we're kind of in that pickle right now because we can't say a word about 1 or 2 of them that have been all over the newspaper. And I do want to say, I think part of the problem in getting people into this table is lawyers over-lawyer their own cases. You know, they think too much about the confidentiality. They're trying to do the right thing, but sometimes just taking a step back would be helpful. Does that make sense?
Yes, it's been a total bar of any information out of the JQC, even from the standpoint of your normal administration hearing meetings, not hearings, but meetings.
Yes.
Preparing a budget, all the things that go on with the operation side.
Right.
The public should have access to that logically. And when you go into the issue of saying now we're going to review complaints, that's when you go into executive session, meaning closing out to the public while that process is being reviewed.
I think the chairman is exactly correct. You know, I was president of a public school board. Now, if you want to take a beating, you know, during rezoning, by the way. So, but I think the chairman is exactly correct. There's just a little bit, the more mystery you put around something, the more the press is interested in it.
And the more negative people feel about it.
That's exactly correct. I think you're exactly right. Okay. I like this one. We should continue to have immunity for the actions that we take. I think that's kind of a given. So, what Justice Namis concluded his thoughts were, and also they are my thoughts, is that we have before us, this is 30 rules. You don't want them right now. I mean, there are red lines and all this kind of stuff, but there are 30 rules. We're really close. We're almost to the end of work. We've been working on 1 rule at a time. Believe it or not, 3 or 4 rules may take 4 or 5 hours. Because we're trying to be really, really careful. And we'll have this done in time for the next legislative session, I assure you, and I'm hopeful we'll have it done by the next cycle when the voters tell us what they want to do. Now, may I, would you help me, Jordan?
Please, yeah, help out.
These are these are handouts. This is in the ideal world of a committee that's been working on fixing the Commission Nominations Commission. In the ideal world of 12 members. If you see, and each of you will have this, you can study it, think about it, but this is our ideal world right here. And it's based on the ABA law. Now, there's some political things here that I don't have anything to do with. Senior elected official, that's usually the governor. Okay.
You might want to sit down that mic. I'm sorry. Number here. I'm sorry, Mr. Tolley. There's number 7 right here. You just pull it up where they can hear you.
This one?
Yes, sir. Just
Okay.
All right. There you are.
All right. So, like I said, this is not about politics to me. This is about fixing the problem. But the ABA's recommended an appointment here, for example, by a senior elected official. There's a couple of places where that terminology occurs. So it could be the governor every time. It could be the Speaker of the House one time and the governor the other time. It could be whatever the legislature says it could be, okay? And I'm fine with that. The Supreme Court would have its appointment. Particularly important would be on the hearing panel, because you would want the Supreme Court to pick its very finest Superior Court judge to be chairman of the hearing panel. And I mean, let's be fair, there are a lot of really fine Superior Court judges in this state, a lot of them. I got 4 of them in my circuit, and I'm lucky. So, you know, I think the Supreme Court should have that appointment. That would be our recommendation. And then we've got one lawyer over here, and of course the State Bar wants us to be the one to either recommend or appoint. Seems reasonable to me that we would do that, but it may not be palatable. I don't know. It's a political question. So this is our ideal world, and you now have small versions of that. So does anybody have any questions about this chart? Okay, thank you.
I wonder about the number. Do you need to have 12, or is it the idea, of course it would be ideal, but the idea of having 9 with, and I guess I'm looking at having the 3 panels, all 3 having the charge of doing investigative work, but if it goes past the investigative stage to a hearing, then it will go to one of the other panels.
That's correct. The 1 3-person panel.
Right.
That stays the same.
Yeah.
Okay. Well, here's the thing. 9-member panels, remember, Chairman Willard, we're free.
True.
So it's not costing the state anything for there to be 12 of us.
That doesn't matter, all right.
We could do it with 9. We'd have 6 and 3. But it's just a more work. There's a lot of work to do, and if we could divide it 9 people, 3 panels, it'd be a lot better. So that's why I said 12.
Okay, we can keep that in mind.
Okay. Yes, sir. That really concludes my remarks, and I'll do the best I can to answer questions. So if there's any that anybody has.
I'm sure we're going to have something. I'm going to start out, Ms. Oliver. We've had sort of a procedural way of doing this, and I'm as chair lead out with the questions, but I'm interested in the committee you talk about. I know this is I call it an ad hoc committee. Can you tell us who serves on that committee in preparation of these rules?
Yes, sir. The committee was, I guess, put together by Justice Namias. He was the designee from the Supreme Court. Justice Namias is the chair. I'm on it. Richard Hyde is on it. And then we have a reporter who's Mr. Carter, who's the ethics professor at Georgia State University, is on it. And the reporter for the commission is Richard Reeves, who everybody knows, with the Institute of Continuing Judicial Education. And I have to say, he has done a yeoman's job. All of these red lines and corrections, and when we get into these meetings, we write all over these rules, and he synthesizes them for us. And I asked him yesterday to give me a synthesized copy, which he did. But I'm happy to have it copied and give it to everybody. I don't think you want it right now. So.
As I understand, there is going to be a report prepared by this committee that will be making specific recommendations for the proposed legislation to be considered in the 2017 session of the General Assembly.
That's correct, I started to say, Your Honor. That's correct, Chairman.
Don't do that. So we're looking then to receive from your committee the report as well as the proposed rules. Of course, the rules will be something to be adopted by the commission, not by the legislature.
That's our proposal, yes, sir.
Right. And we talked a little bit about open meetings, and I said that the thing that I feel strong about is we didn't do a good job of addressing this, and I profess and confess about that, is the current Bill 808, House Bill 808, had a lot of things being happening at the last minute, recognizing that we were going to probably be addressing it again, assuming the constitutional amendment does go through.
Yes, sir.
And certainly I think that open meetings issue is one that we want to be clear about, and open records where the lines are drawn, and especially with looking at normal business procedures, those things should be available for the public. I've heard reporters talk about, well, we can't even get an understanding of numbers of what is pending and what's been processed as far as complaints by the commission. I think that's something should be done on a regular reporting basis to cover those items when needed.
That we, I don't want to interrupt you,
Yes, sir.
Chairman. There actually is a website that has a lot of information on it, but the reporters don't seem to be able to find it. But listen, I agree with you.
Okay.
That we should make it as easy as possible for these people so they don't complain.
The issue of advisory opinions, that's been I think, a concern. I see a judge in the back here has some concern about that with right or not, the issue about open courtrooms, for instance. And I was really, one of the things dismayed, and I guess part of the catalyst of my becoming more concerned about the operation of the JQC was the fact that a position was taken by the JQC that we're the ones that make advisory opinions, and you, Supreme Court, can't even question our opinions once they're adopted because you're a judge, and we're charged by the Constitution to police you. That's the point about it. If you go back and listen to the hearing in the Supreme Court, that's sort of the essence of what came out of it to me.
Well, I wish I was more informed, but I'll tell you this. I would be very reluctant to tell the Supreme Court they can't tell a member of the bar.
Well, that's my point.
Yeah,
the Supreme Court is charged with adopting and, say, policing through the canons of judicial conduct code what is permitted actions by a judge.
Yes, correct.
Advisory opinions are made as a supplement, you might say, of interpreting those rules.
That's correct.
And certainly, to me, to say that the Supreme Court cannot make a review of those promulgated advisory opinions is just, I think, a very short-sighted place for some people who are on the JQC to take that. And I don't know if it's being taken as a body or taken by individual members, but it appeared as a body before the Supreme Court on that basis.
That has not come up in my tenure, but I'll say this. I think like a lawyer. If you look at the federal rules of evidence, right?
Yes, sir.
The rules are promulgated by a commission. They're advisory opinions, and all of that stuff is subject to the United States Supreme Court's approval and correction.
Federal rules.
Federal rules. That's correct. Yeah, that's right. Well, that's what I meant, federal rules, yeah. But, I mean, that's a good analogy there.
And I agree,
Yeah.
State rules should be the same way.
They should be.
But we don't do it that way.
But, I mean, I haven't thought it through, but I got to tell you, my reaction is I rule in your favor. I would have to believe that the Supreme Court of Georgia has the final word. Now, that's a different issue than if, God forbid, we should ever have to look at disciplining a Supreme Court justice.
I know.
I mean, I wouldn't want to, but, there may be a time when that has to happen. But that's a different issue.
That's right.
I
You
see
never
it as
know.
a different issue.
Tara Moon, I've never met Ms. Moon. I've heard nice things about her. We invited her to come and appear for the same reason, to get more information about the operations of the JQC. I've heard, let's say, hearsay, perhaps, but she was directed by those within the JQC itself not to come to these meetings or a meeting.
I can't really speak to that, and I'm not ducking the question. I will say this about Tara Moon. She's I hope she doesn't mind my saying this, kind of a quiet country girl. She comes to work with a lunch bucket every day, filters through these complaints, answers questions, does all of the dirty work. And I think, frankly, from her perspective, she'd probably be scared to death if she was sitting here right now.
Well,
and I'm not suggesting that it was inappropriate to ask her to come. And if somebody told her not to come, it certainly wasn't me.
I know, I don't know if you heard that or not. But the point is, I go back to when we had legislative hearings, Appropriation Committee hearings, and Mr. Dollar came, and we talked about some things going on. Ms. Taylor, excuse me, I apologize, mispronounced his name. Mr. Taylor came, and one of the things that we were finding out about through that process was there wasn't really an office of the by that a physical office place of the JQC. And so the question was being asked, well, you got all these confidential files of judges about complaints and processes handling them. I said, where are they kept?
Yeah, you know, I
And
had
they were kept at the home of Ms. Moon.
That's correct. And they have been moved, my understanding, and I haven't verified this, but I believe it to be true, they have been moved to the AOC office that we have now.
Good.
I think the Supreme Court also had the same concern. I know if there are judges back here in the back of the room, I'm sure they have the same concern. What good is confidentiality? Well, my belief is, and I'll verify this myself, that try to do it tomorrow, that these files have been moved to the AOC office.
And I've heard that they have been, that the AOC office has, but I mean, that's the kind of thing, for 70 years, or not 70 years, excuse me, I'm back apart, since 1970, 40 years, they've been operating in that vacuum, I'll call it, without.
4 decades before
Yes, sir.
we've addressed these
Yes,
rules, and I'm with you. I think you're right.
Let me give you a couple of things I hope that your committee will give consideration to, and that these are things that have come to mind or been brought to my attention, and it may be as a result of some things we found out with the conduct of the commission, but I want to talk about, for instance, if a member of the JQC is to recuse themselves from considering a specific complaint. To me, I think the process on that particular complaint should be held in abeyance until all slots are properly filled, and those right now, the 7 slots, as opposed to just saying, well, now we'll travel with 5 slots or whatever the numbers may be. I think there's been times where, and I know, for instance, with Judge Becker, there were two individuals who recused themselves, and the case went forward. To me, if you're recused, and this is a situation where you got a finite number of members, you need to have the right to be sure you got a continuing number that was properly constitutionally given to you for that purpose.
And let me comment on that. You're exactly correct that there is presently not a mechanism to replace a recused member. And so in order to bring the commission work forward, it is true that with less than 7 hearings, or not hearings, but decisions have been made. If I'm Judge Becker, I want 7 people too. I don't blame her. But the way we are presently constituted, we couldn't do it that way.
Yes, sir.
We'd never get finished with anything. So, but I don't disagree with you. I think that's a good idea.
And I think there probably needs to be some clear guidelines as to under what standards somebody should recuse themselves. For a judge to say, well, I recuse myself because I knew the judge, I said, my God, you're going to know every judge that comes before you probably. I mean, how can you say,
yeah,
really?
I would probably. Yeah.
And that's not, that to me is not a basis to say I want to recuse myself.
We should recuse ourselves in situations similar to those that a Superior Court judge would choose to recuse themselves. If there's an appearance of impropriety because of a relationship with the judge, if I've worked for that judge as a private lawyer, there are times when you need to step aside. But you can't, if you either need to get off the boat or stay on the boat.
Right.
You took the responsibility, face up to it. Judges every day have to look across the desk and sentence people that they might have grown up with.
Oh, yeah. And in most communities, you're going to know probably 75% of the people that come before you as a judge.
Sometimes I feel like I know everybody in Athens, Georgia. Yes, that's true.
Here's another situation I've heard about that raised concern in my mind. That is, you have the situation of a judge who has a complaint pending in the JQC. And we have attorneys who are appointed members of the JQC. And now those attorneys are appearing before that judge while there's a pending complaint. And the judge does not recuse themselves. Now, let me finish this point.
Yeah, I'm thinking.
The other side doesn't even know that there's a complaint pending. But I'm concerned about the independence, we'll say, of that judge who is now facing an attorney that has the ability to render judgment about their conduct through this pending complaint. And I don't say the judge has to make any comment about, I'm removing myself because, but I think something needs to be by the rules. and it may be the judicial rules themselves as opposed to the JQC rules. But I know of 2 instances where I've heard this happen, and I think that is, to me, improper. I think if a judge has somebody before them that has in their hands his or her future about how something may happen to them, it puts the judge in an uncomfortable place, and the other attorney doesn't even know it's happening.
Well, you remember what I said when I first made my opening remarks. I remember those days. I wasn't aware of the 2 situations you're talking about, but first of all, I fault the lawyer. The lawyer should have enough integrity to inform the other lawyer.
Right.
You know, I mean, you know, remember
One of the cases occurred that way.
Yeah,
but
remember what I said a minute ago, that the process, it's a lot of times the process is fine, it's the people.
yes, sir.
It's in a matter of integrity. That lawyer should not have done that.
Yes, sir. Or the judge.
Or the judge.
I think the judge has a responsibility to be aware that, you know, I know there's a complaint against me, and I know he serves on the JQC. I should not be hearing his case under those circumstances.
And that should be addressed by rule. I think you're correct.
Tell me about, and I know you haven't been involved long, Ms. Tolley, with this, but the issue of these informal hearings, I think it's very vital that the work of the JQC have the ability to continue with bringing someone who's a judge before them and counseling with them about what may be involved with the complaint. And that should be done, and I call it an informal setting. And we've had 2 cases, as we all know, in Georgia that we had judges come before them informally, as we were called. The meeting was called, and out of those meetings, the contention was the judge gave false information to the JQC and then was prosecuted criminally for that. I don't know how your rules are going to address that, but I think it needs to be something that the JQC and its workings for the future should have a clear line of understanding to any judge who's come before them. If you're coming in informally, you're not going to be required to be under oath. There won't be necessarily a recording of your meeting unless you consent to recording, and when you do a recording of it, it is so stated on the recording. Just like when a police officer brings you in and you do a questioning of them, do we have your permission to record this statement? And the party says yes or no. And if it says yes, then you say, here's the recorder, and we put it down there. But I've heard from judges say, well, I found out my meeting was recorded, I didn't know about it. True or false, I don't care. But the fact is, at least we understand from Judge Becker, it's recorded, but not done. But you still have the right to bring in somebody and say, now, Judge, this is a little different standing. We're going to put you under oath. You're subpoenaed or something to come to this meeting, and the purpose of it is to take sworn testimony. Now, if you take sworn testimony and you lie, there are standards in the law that address that. But I think we have caused a chilling effect upon the works of the JQC when there is now requesting judges to come in to do what I call the necessary counseling work. And do I go in or not? Because I don't know what they're going to do to me out of that meeting. If I were a judge, I'd say, thank you, no, just send me some written questions and I'll give you some written answers. But I'm not going to put myself in that kind of position. I say all that because I hope the rules that your group is looking at somehow address that kind of problem so it doesn't happen again in the future.
I hate to keep saying I agree with you, but I agree with you. We've had, since the Becker matter, since I've been on there, and it's not because of me, it's because of the commission. I can't speak to Becker because I wasn't there, but the commission is, in my understanding, has kind of gone back to its old way. We've had judges in informally. They took the leap with the assurance that it wasn't informal counseling, and I think it's been very beneficial. I can think of one young judge in particular I think it has benefited. So,
and that's what we want.
Yeah, absolutely. You know, if I can use, you know, I'm a trial lawyer, so I think in analogies. So if you'll bear with me a minute. If the auditor for the University of Georgia audits a fund, okay,
yes,
that auditor comes back with 3 levels. Number one, this employee needs counseling.
Yeah.
Level 2, this employee needs discharge. Level 3, this employee needs firing. Okay? I mean, excuse me, needs prosecution. So you're really saying the same thing here. You've got levels. It depends on what somebody's done. And I mean, I completely agree with you, and I think it can be addressed by rule.
I do too, and I hope that's something that is and I say this because I know some people are looking at us over TV, and I hope that's understood that is a point of I think concern a lot of us have as legislators and public about what may have happened. Ms. Oliver, do you have anything you'd like to ask Mr. Tolley?
Thank you for being here. You've been very helpful, and it's very encouraging to hear the depth of work, quality of work that y'all have engaged in to come forward as far as you have. Do your proposed rules, and I don't want a copy today, include a definition of when a judge is entitled to a written notice of a charge, and whether or not there's a definition of an exception of some kind of emergency definition where a judge would not be entitled to a written charge, written information on investigation and charge?
Of course, in the rules, there's a provision for the judge receiving written charges if it's appropriate. And there is an emergency provision, but I don't want to quote it from memory because I'd probably say it wrong. I mean, we obviously have to have an emergency provision, but I can't remember exactly what it says.
I don't need to hear the details of it, but I've come to the opinion, and your opinion's much more important, you being the JQC rules, is that a judge is entitled to written notification if an investigation and charges are being investigated. And secondly, there are some circumstances, very narrow, when a judge would not be given that written notification. And I'm hoping someone can clarify in a very intelligent way that I assume y'all are doing, that is what your rule might look like.
Well, what jumps into my head immediately, and I don't want to pick on any one Superior Court judge, but we had a Superior Court judge that wasn't on the commission. The guy used to be my law clerk, so I paid attention, who had a really bad day and pulled a gun out in the courtroom. That was an emergency removal. There's got to be room for something like that.
I've come to believe there has to be room for an emergency.
I do too.
And I want to hope that your rules encompass a definition that's very narrow.
Yes, ma'am.
Anything further?
No, sir.
Mr. Meadows, let me get your number, please, sir, and that's number 25?
25.
Yes, sir.
Mr. Tolley, thank you for showing up. How many members active is on that commission right now?
Well, we have a vacancy, so 6.
6. Is that vacancy the director, is that an outside?
It was Judge Weaver who's resigned.
All of them are lawyers, I assume?
Well, Mr. Hyde's not. He thinks he is, but he's not.
I tend to listen to Mr. Hyde probably quicker than anybody else. My question to you, did you come here under the fact that we believe that we have subpoena power, or are you here just on your own free accord, which I think is the answer?
That is the answer.
That's what I thought.
I'm here. I'm here. I'm going to be honest with you. I'm here because somebody needs to talk about this. I got tired of reading in the newspaper about stonewalling and not being open with the committee. I mean, I don't know what people think, but I just thought it was important to be here.
I hate to tell you this. I don't know how I'm going to take the fact that I've got a group of lawyers, except for Mr. Hyde, who would just downright die if somebody didn't honor a subpoena that came to them.
Sure.
Fact is, they would ask the judge to have them put in jail, have the sheriff's department go get them and put them in jail. We're appointed this committee to, believe it or not, to help. We'd like to air out what seems to be the problem and find out what the problems really are. I don't think that the other members of the committee who won't come sit there, and the last time I checked, I've been up here for all but one, we hadn't been mean to anybody. I don't think that we would be mean to them, but we certainly would like to know from them how they think they should operate and under what rules. And it's blatantly apparent that the rules need something.
I agree.
I don't know if we just do away with them and start again.
Well, that's what we're doing.
Well,
We're starting again.
then are these rules going to be adopted by y'all? We can't adopt them. It's got to be done by y'all. And you can adopt rules that basically say the state Supreme Court doesn't have any control over us.
I probably won't vote for that one.
Be a pretty good idea.
I think the reality of it is that my sense of the commission members is that if we get these rules cleaned up and they can be adopted, then we've got a Supreme Court justice who's very, very active. I've had a little fun with him today. I'm probably going to hear about it. But he's very active and very meticulous, very meticulous. I think that these rules will get adopted.
Well, I, for one, happen to think that the legislature has the power of subpoena. I think that 4 of your members are violating that subpoena. It's a personal affront to me to take my time to come down here every Thursday and try to get informed. Again, no lawyer, insurance man. But I come down here and sit on this thing expecting, 1, to get educated, 2, to find out what the problem really is. And I do not like it. And you can spread this to your fellow members. I don't like it a damn bit that I'm here and they're not.
I hear
And I do appreciate you and those back there that showed up on their own accord to come here and try to give us some information so that we can have a recommendation. And we certainly don't want to make a recommendation until you've adopted rules. But they ought to be able to sit there and tell us that. You have a nice day.
I heard you.
Chairman Meadows is a former mayor and also, as I understand, presided over municipal court. So,
Hey, I told you, I'm fine. It doesn't bother me.
thank you. Mr.
And
Kelly.
Listen, let me tell you
Yes,
something.
sir.
I appreciate your remarks. I get it. Yes, sir.
Thank you, Mr. Chairman. Mr. Tolley, thank you for being here with us today, for coming, and for all you've done for our UGA athletes. Appreciate that. Do you have thoughts on this weekend? Are we going to be all right against Tennessee, you think?
I wish I could play. I'm big enough now to be a lineman. So, it's going to be a tough year.
When Nick Chubb's my constituent, so I'm hoping
Are you from Rockmore?
I'm from Cedartown.
Mike
McCrae
was my fraternity brother. I'm sorry to tell you that.
We'll talk after soft line.
I'll probably have to lie, but go ahead.
I appreciate also that you have come and you've agreed that this study committee here has an important purpose. As I'll echo Chairman Meadows' statements, I wish more of the members of the JQC had the attitude that you do and that Mr. Hyde have. We certainly appreciate that. You've said twice now that the process isn't broken, that you feel there's more of a problem with the people. And so my question is, what can we do and what are y'all going to do with your proposed rules to protect the process from the people?
Wow, that's a loaded question. I'm not sure how to answer that. I think if these new rules are adopted, which I'm confident they will be, it'll take care of a lot of the problems that have occurred in the Becker case and with your magistrate, I think it was, from Bartow County. That's the best way I know to answer it. I'm not sure with this, the way it's set up right now, our hands are pretty much tied. There's some members of the commission, I'll say on their behalf, that just fundamentally believe they shouldn't be here because of the way these rules are written. That's a lawyer. Lawyers can differ on their opinions. I don't share that opinion. That's why I'm here. But there are others that do. And we also have a sitting judge who has concerns about being here as a sitting judge. So that's their dog to argue out, you know. But I'm comfortable being here. I really want this to work, okay? That's why I'm here.
I think we all do, and we certainly appreciate that. You mentioned the exception for confidentiality, and I think one area you referenced was the JNC and providing the JNC, I think you said with complaints, and I was wanted to make sure, are you talking about any complaints that's been made or complaints that have required either discipline or counseling slash instruction?
I might have to be counseled by Mr. Hyde on this, but my recollection is when the governor asked for complaints, he asked for all of them,
okay,
whether they've been processed or not, you know. That's my recollection.
Mr. Hyde last week talked a little bit, something that I found troubling was that some information that we believe may be going into the JQC isn't shared with all the members. What are y'all doing in the proposed rules to make sure that doesn't happen again? Because that's not fair to someone like Mr. Hyde, who is a member of the commission.
My opinion is that every commission member is a constitutional officer, and therefore they're entitled to whatever information any other officer is entitled to. We should all have the same information. I believe that Mr. Hyde was very recently furnished a thumb drive with everything he requested. He would have to speak to that, but I think that did happen.
Mr. Hill, who I think the JQC retained at I think around $550 an hour to protect the commission from what we believe is our rightful subpoena power. Can you tell us who made the decision to hire Mr. Hill?
Well, the commission made that decision. I wasn't. This sounds very naive on my part, but I wasn't actually sure that subpoenas issued to these folks. If they did, I didn't know it.
Let me clarify that at this stage, we have not actually issued any
That's
subpoenas.
what I thought.
It was a preemptive hire, is what I think.
Challenge that power. Yeah.
I'm not going to dodge the fact that I voted in favor of getting advice from Mr. Hill. I mean, I don't remember whether you're a lawyer or not, but they always say that.
Barely when I'm not up here.
Yeah, well, I know the feeling, especially since I got into this. But, they always say that we lawyers have fools for a client if we represent ourselves. I think that the more cautious members of the commission thought they should get legal advice. Because when you look at the confidentiality rules as they presently exist, I just think people didn't want to make a mistake. Bill Hill is a well-respected lawyer. I hope he didn't charge us much. So I'll confess that I voted to allow him to give advice. I don't know what else there is for him to do. I'm sorry that's the best answer I can give you.
That's fine.
Okay.
Final question.
Yes, sir.
And I'll again preface it by just telling you thank you for being here today.
Thanks.
And I think I know the answer, but I just want to be sure of it. Do I understand that you will be voting in favor of the constitutional amendment?
It appears that I will be. Okay. And as I told the chairman, that's not how I started out. I didn't realize how busted the process was. I mean, 4 decades and no corrections. And the reason I use a state patrol example is it's easy. Everybody else figured it out 30 years ago, and we're still doing it the same way. And so, I knew Arthur Bolton, and I respected his process when he said, you're entitled to a minimum of due process. But I think when we're talking about removing judges, particularly Superior Court and State Court judges that have been elected by the people, they're constitutional officers, I think it requires more than minimum due process. That's my opinion.
Well, I appreciate that. Go Dogs.
Go Dogs.
Okay. One last, I'll just comment with this issue regarding who has appeared and who has not appeared. I heard from Ms. Evans, she has some health issues.
Yeah, I was going to tell you
and
that.
she's not able really
she's
to
not
appear.
able
And
to be,
I talked to her and I said if she wanted to send some written comments, I'd be glad to share that with the commission. She may do that or not. I'm not saying she will or won't, but just in that regard, she is not really capable of appearing right now.
I completely agree, and I'm aware of those health problems.
Right. So it's 3 others I think we're talking about that.
Right. And bear in mind, one of those is a sitting judge, and she had some real concerns about testifying because of the fact that she's a sitting judge. Now,
I don't know why. We're not dealing with anything she's got as far as judicial matters before her. It's a matter of judicial qualification commission that she's participating in. Anyway, we're we're grateful for your being here today. I'm also want to express again how grateful we are when I heard you were going to be on the commission. I thought, well, that's a good turn to be made.
I hope it turns out.
And I'm waiting to hear who the Supreme Court is going to put on there as far as a new judge. I've heard some stories about it, but maybe something be coming soon. We'll get back to par on that.
The chairman probably knows more than I do.
Not really. But I did know the fact that you're getting a new investigator, and that's very, very important. And I think the field that you're getting it from is just what I felt needed to be somebody either with the GBI or the FBI experience, because that's investigators, and that's what they do.
And I'm happy to also report, Mr. Hyde knows this investigator from years ago when he was a cop and a police officer. And,
good.
So we both know she's qualified. And I had to strong arm her a little bit, but she's going to be with us for a while.
Super. That's glad to hear you.
Yep.
Well, thank you so much
for
being with us today. I'm going to take about a 5-minute recess. We're going to stand adjournment at this time and come back in about 5 minutes, please. And we'll have, I think, the lady, Ms. Temple, to speak to us. We adjourn, yeah. All right. I want you all to stay for us.